These highlights from the Probate podcast will help you navigate life transitions like a pro. From senior living to estate planning to probate, you'll learn incredibly useful tips. Be sure to like and subscribe to hear more from Sherri Lund and her expert guests.
What's another avenue of avoiding probate that you could?
So for your bank accounts, as long as they are joint bank accounts, say that you have a bank account with your spouse, and you are named jointly on those, whoever dies first, the account is still automatically in the surviving spouse's name. So making your accounts joint is an option to do that. And then also naming a payable on death person. It's kind of like that beneficiary designation, but a little different. Usually this is only with bank accounts, and you can go to the bank and say, look, when both of us are gone, I want this paid out to this person or persons in whatever shares you want, and they will pay it out just like a life insurance policy. Again, avoids probate. Nobody has to go and get authority from a court to go access that bank account.
So I know of a scenario where a woman had her adult daughter sign on her account, to be able to pay her bills and to be able to pick up medication and that sort of thing. Is that a good idea? Is that kind of what you're talking about here, or is this something different?
It's something different, not necessarily a bad thing to allow someone to be a signer on your account, but that really only gives them authority while you're still alive, right? There's other ways to give somebody authority to sign on your behalf, and that's through a legal financial power of attorney, also called a statutory durable power of attorney, that can give someone else legal rights to access your bank accounts, write checks on it if you give them authority to do. But again, that only works while you're still alive. If someone is not an owner of the account, then they don't have any rights to it once you're gone, unless you have made it payable on death or it goes through the probate process.
So then that account would be frozen?
Correct.
Okay. So what if the person on that account takes advantage of the money that's in that account? And there's other beneficiaries that have a right to those assets, but it's a catch-22, isn't it? Because
it is a catch-22, and that's the risk. That's definitely a risk when you give someone authority on your account. There's a risk that other beneficiaries, when you're gone, aren't going to get what's left because it may not be there. That's always a risk. When you name somebody as a power of attorney or put them on your account, you just have to really make sure that you are designating people you trust. There are options for the other heirs to come back and sue the person who took advantage to try to recover those funds, but obviously that's not ideal.
Yeah.
To catch the full episode and explore more resources from the Probate podcast, check the links in the description and be sure to subscribe for more tips each week.